Civil servants hatch legal plot to sink Rwanda bill, says the front page of the Telegraph today. Well, imagine the shock for the Telegraph when it finds out that what the FDA union is courageously doing is defending the integrity of the civil service, upholding the rule of law and the administration of justice.
The bill contains a very specific power that makes it clear that it's for ministers to decide whether to comply with temporary Rule 39 orders. Now, we wouldn't have put that power in there unless I was prepared to use it.
That was the UK Prime Minister Rishi Sunak proudly announcing at a press conference that he's willing to break international law to get flights off the ground to Rwanda by ignoring Rule 39 orders, which are issued by the European Court of Human Rights on an exceptional basis where there is a real risk of serious and irreversible harm.
Are you prepared to breach international law in order to get those flights off?
So look, if you're asking me, are there circumstances in which I will ignore Rule 39s, and the answer is clearly yes.
Ignoring a Rule 39 order would be a breach of international law. And the Prime Minister knows it. The President of the European Court of Human Rights immediately responded with this.
There is a clear legal obligation under the Convention for states to comply with Rule 39 measures.
Again, it's clear from that statement that the UK will be in breach of its international legal obligations if it refuses to comply with Rule 39 orders. Which isn't surprising given the government's own legal advice also states that failing to comply with Section 39 orders would be a breach of international law.
But what we have also done is amended the guidance for civil servants that make it crystal clear that if ministers do make that decision, that civil servants will implement that decision.
That was the Prime Minister saying he's amended the guidance for civil servants so that a minister can direct a civil servant to ignore a ruling of the European Court of Human Rights. Just think about that. It would mean a civil servant being told to break the law. Civil servants have a legal obligation under the Civil Service Code to uphold the rule of law and administration of justice. Neither ministers nor guidance can overrule the legal obligation of the Civil Service Code. Only another Act of Parliament can do that. So this creates a potential conflict between any instructions that might be given by a minister and the legal obligations under the Civil Service Code if a minister was to decide to ignore Rule 39 orders. So in that context, just listen to what the Prime Minister said again.
But what we have also done is amended the guidance for civil servants that make it crystal clear that if ministers do make that decision, that civil servants will implement that decision.
Now all this has left the FDA union, which represents civil servants, with no choice but to mount a court challenge to the government's new Rwanda law by submitting an application for judicial review over whether a minister can direct a civil servant to ignore an ECHR ruling. The union wants the High Court to decide whether that would mean the civil servant was breaking the law, and therefore the Civil Service Code of Conduct. And remember this, if a minister was to ask a civil servant to do something that broke the law, that civil servant would have a legal obligation to refuse. And neither ministers nor guidance can overrule the Civil Service Code. Only an Act of Parliament can do that. So for taking this action, the country should applaud and stand shoulder to shoulder with the FDA union and its members. No one is above the law, not even this government.